hearing of the National Democratic Congress's parliamentary candidate stay of execution motions have been forced into adjournment after it appeared to the court that the bailiffs were unable to discharge their duties. The parties involved have not been served with the processes, and in fact, this led to some delay in the calling of the case. And after subsequent calling of the case, it came to the fore that there's no proof of service and there's also no proof of non-service. So it means that the bailiffs have not performed their duties, and the managers of the bailiffs were invited by the court, and Madam Victoria Mensah indicated to the court that yes, after inquiring from these bailiffs, it came to the attention of her that they haven't been able to perform their duties, for which reason she will be issuing some query letters to them for them to respond why they were unable to perform their processes. This led to the court adjourning the case after the parties, especially the NDC side and the Electoral Commission side, agreed to come back on the 13th of January. But the Director of Legal Affairs of the NDC, GHOne, has this message moments after the case was adjourned.
It has to do with the fact that the applicants were not, that the mandamus applicants were not served with a stay. And my law says once it's fundamental and there's no proof of service or proof of non-service. However, the Electoral Commission were in court, except to say that it was their watchman that was served on the the day the mandamus application was granted. We thought it was more between us and them, so we could proceed. But like the concerns raised by my lord is equally fundamental. So in the circumstance, we are supposed to come back on the 13th of January. But as you are aware, the Electoral Commission is currently even doing Ablekuma North or so, knowing very well that these processes, and in fact they have filed an affidavit in opposition. Why in God's name would you go ahead and be doing these others, the ones you have done already, and Ablekuma North, when you know we are in court over this matter?
In relation to whether the long adjournment will have a toll on the members of parliament elect, he said, look, they shouldn't kill themselves over the fact that swearing in is going to be done today.
We can always, the issue of swearing in is not a matter of life and death. So that can always be taken.
We understand that you have some processes also filed at the Supreme Court. What exactly are these processes?
Later we'll talk about that. Thank you.
Clearly, the numbers that we used to know are associated with these very cases have drastically reduced today. We didn't see the numbers in court today for obvious reason, because the Electoral Commission has gone ahead to make declarations in relation to these disputed constituencies following the orders of the High Court, even though the NDC side disagreed. As a result of that, they have filed processes at the Supreme Court by way of a judicial review in the nature of certiorari to quash the ruling on the objection that was overruled on the 1st of January, and also the ruling of the court on the mandamus application, which was granted on the 4th of January. Until such time that the Supreme Court calls for the case and dealt with it, the orders of the High Court will still remain. From the High Court here in Accra, Murtala, Inusah, GHOne.